All right, so news is breaking all around the industry right now, both on what's happening with the XRP and the Ripple case, but also how this may affect Coinbase, which really could be one of the biggest scenarios that plays out either positive or negative for not only the crypto markets, but blockchain in general. So we're going to break that down today from a legal standpoint. I think you guys are going to love this one. My name is Paul Barrow. Welcome back in here to TechPath. If you guys are joining us over on the TikTok right now, make sure and jump over here to YouTube. We're streaming over on TikTok for a little bit to kind of get things going about what we're covering. But make sure and come over here to YouTube. We are streaming live here on YouTube. So again, getting into Coinbase, we'll break this down for you guys today. We always love to have I would say our best legal analyst out there, and that is, of course, James Murphy, MetaLawMan, joining us today. So welcome him back into the show. Great to have you, James. Hey, James. There he is.
Yeah, you froze on my screen there for a moment, Paul. It's wonderful to be with you, and it's boy, is it a big day
Huge
in the crypto world.
Yeah. All right. So a couple of things. I want to lead off with your tweet today, and the ruling XRP not a self-investment contract. Significant blow to the SEC's case on Coinbase and their other crypto exchanges. Even though it's not a binding precedence, which we'll talk about in a second, it's extremely well reasoned that this will be cited in all motions for a dismissal, all of that. Just to be clear with everybody that the XRP case wasn't decided today. It was simply a summary judgment. Explain to us the path now for the SEC to take this into court, and what's the likelihood of anything happening over in a court ruling?
So it's a split decision, but mostly in favor of Ripple, Garlinghouse, and Larson. And I think it is appropriately viewed as a very big win for them.
Right.
The SEC won on one claim. They got summary judgment on one claim, and that is that the judge determined that their institutional sales of XRP to institutions like hedge funds qualified as an investment contract and therefore was the sale of an unregistered security. They lost everything else in terms of other sales by Ripple, as well as sales by Garlinghouse and Larson personally were determined not to be sales of securities. So that's really big. The only thing that is left for trial is whether Garlinghouse and Larson aided and abetted the sale to institutions of XRP, the only thing that the SEC won on. So that's not really a lot to go to trial on. And in a normal case, without so much focus on it, the SEC would normally drop that count, avoid the trial, and go straight to appeal. But when it comes to appeals, we have this rule in our court system, and that is you can't do piecemeal appeals. You can only do one appeal when there is a final judgment. So if the SEC decides to proceed to trial on that one claim of aiding and abetting, it delays everything. They can't appeal until that is done. So that's the decision point for the SEC now. Will they proceed to trial on this one claim, or will they drop it and just go on to the Second Circuit Court of Appeals?
Yeah, I think this tweet from Cochran kind of supports that Ripple case here, good and the bad. Mostly very good for alts and surprisingly big win. Is this a surprise to many people? I don't know that it is a surprise. It was just a surprise of the timing. First judge did decide institutional sales fundraising was securities, back to your point there on that. And within this kind of framework, you look at what's been happening with Polygon, Cardano, Solana, all getting delisted off things like Robinhood, future uncertain in many cases here in the US. What does that do for the altcoins themselves? Does this give them a little bit more credence? What is your feeling around this?
I think it's definitely a helpful development for all of them. And the reason is that it's very helpful to the exchanges. This decision, while it doesn't hold that secondary sales are definitely never securities transactions, it very, very strongly implies that. And therefore, Coinbase, Bittrex, and to a significant extent, Binance benefit from this decision because it's well reasoned. While it's not binding precedent on other courts, it's really helpful to have won this first big one. And if the exchanges are not at risk for listing these assets, then I think they're going to be more receptive to relisting assets that they've delisted for fear of SEC action.
Right. I was looking at Tom Emmer. He's been on our show before. He's now the majority whip, and he basically states here, Ripple case, monumental development in establishing that a token is separate and distinct from an investment contract. It may or may not be part of, and now let's make it law. So we do have some very interesting legislation rolling up on us. We'll talk about the Loomis bill here in a minute. We will also have the bill coming in from the House that we've been following. We think it's the one that most likely, both from a stablecoin aspect, but also within just digital structure, we'll start to see some more. When you look at lawmakers now, and you've had a chance, obviously, as a securities attorney, retired, but you've worked with the SEC in the past. You've seen the impact on lawmakers. Is this really a big deal to lawmakers as much as what Emmers is talking about there?
I think so. You see people like Richie Torres on the Democratic side coming out with a shot across the bow at the SEC. Many of them have been saying this whole approach of regulation by enforcement is wrong, violates the Constitution and fundamental fairness. And so this judge pushing back on the SEC trying to have all sales of XRP declared illegal sales of securities, I think gives some impetus to those to the people who've been on that side saying the SEC is going beyond its authority. And I couldn't agree more with the position that it needs to be, Congress needs to do something to make clear what the rules of the road are when it comes to regulation of crypto assets and the exchanges upon which crypto assets are traded.
Yeah, we're definitely going to get into the Coinbase side of things because I think that obviously will be the next handful of front page news items that we'll be hitting. Caitlin Long hits in. She comes up with a prediction here and says, now that the Ripple summary judgment is in, regulation into further disarray, Congress will finally act. Federal financial regulators usually don't open themselves to litigation that could massively cut back their jurisdictional grab. The SEC did. What happens here? Does the SEC get kind of taken to the mat here with all of what's happening right now? What are your thoughts on that statement?
Well, there's a lot there. So one aspect of it is that the Supreme Court of the United States has been reining in agencies, executive branch agencies quite a bit recently with the, West Virginia versus EPA on regulation of carbon dioxide and the student loan ruling more recently, the Department of Education, acting there, two agencies of the executive and the Supreme Court has come down pretty hard. And I think that the same fate lies with the SEC if they get to the Supreme Court on some of these cases. Meanwhile, Congress, it feels like maybe a little bit of momentum. What is interesting, and maybe we'll go more deeply into this, Paul, but I haven't seen the regular kind of knee-jerk reflexive denouncing of the Lummis Gillibrand bill like you might have seen last year. So I don't know what that means, but it could be a good sign.
Okay, so Man, there's so many things going on right now. It feels like all of this is just almost in concert, or if it's just finally come to a head. And plus, we're obviously getting ready to go into an election year. Who knows what that is going to do with what we're going to see in the markets in general, open markets on securities, as well as crypto. Eric Voorhees also been on our channel before. XRP case today suggests that a project can do an ICO so as long as this is a big one, so long as it sells the token publicly on an open exchange at the same time that other holders can sell on the same terms. Sounds reasonable. And then right behind that, I think it was this tweet right here. Was it this one on the security? But the point was, maybe it was this one. I'll find it. But we've got one where they break into the issue of even VCs now not being able to kind of go behind the scenes on projects in the past, which is what we saw in the last run. If you're a token or a project that's getting ready to launch now in the United States, and you're a founder or an investor that's going into that market, and you hear this news from XRP, and you go call your securities attorney right now, are you saying we want to proceed with our roadmap planning, or are you still holding your cards waiting for additional clarity here?
Well, that depends on your risk appetite. So I believe that an appeal by the SEC is likely because this decision does undermine, much of their enforcement agenda in crypto significantly. And so if they want to continue on this path, they're going to have to appeal. And so, there's risk that the decision will be reversed. I think the decision, for the most part, was absolutely correct, well-reasoned, based on an understanding of the law. And so it's probably going to be upheld. But with respect to Eric Voorhees' point, it's interesting. Judge Torres and Ripple said when Ripple sold XRP on exchanges to unknown purchasers, right? That was not the sale of a security. That's his point. And it's a good one. If that idea is upheld on appeal, then I think that is going to become a very well-traveled mechanism to distribute tokens.
Well, and it changes the whole dynamic of how the entire investment architecture works today, because with blockchain, all of this has really kind of upended the current securities market. If you're an investment going out and raising capital, you're looking at different models of doing that. If you're doing it in the open market and it's because of blockchain, completely transparent, it really does change it quite a bit. Hey, listen, James, we have some breaking news here. XRP has now been relisted on iTrust, brought in. And for many of you guys know that iTrust is a sponsor of our channel, not paid on this particular episode, but XRP now available over on iTrust. So this may start a cascade of more tokens of this particular token, meaning XRP, rolling out into the exchanges much faster. I'm surprised that already with just the summary judgment that this is already taking place in the United States. So kind of crazy.
Yeah, it had to be in process. That's not the sort of thing you flip a switch. It takes some work. So they were ready for this decision. And I agree with you, what you said at the beginning. It's not a surprise, that XRP traded on a secondary market doesn't violate the securities laws.
Yeah, very interesting stuff here. Paul Grewal comes in. Now we're going to kind of flip over a little bit over to Coinbase a little bit, because this has huge impacts and effect on Coinbase's case right now. So Paul comes in, he says, we've responded to the SEC statement of intent to move to strike. Coinbase's defense rooted in the major questions doctrine, abuse of discretion, equitable estoppel, unclean hands, lashes. I don't know what that means, but you're going to explain it to us. And we look forward to addressing the court tomorrow morning. This, of course, all happening before the XRP summary judgment. So this strategy that Coinbase has begun already, and we've talked about it, you and I, often on Twitter in the DMs, of how fast they're moving here. Does this change any strategy for them?
No, it simply changes their brief. They're going to now point to this Ripple decision very prominently in their brief. Bittrex, which is a little bit ahead in that they filed their motion to dismiss already. It's the same claim exactly as against Coinbase, a failure to register as a securities exchange. They will submit a supplemental authority letter for sure to advise the judge in that case of what's happened here. And it's very, very beneficial to the position of these exchanges. It doesn't change the timing, but it certainly adds a heft to one of the arguments that they intended to make anyway, which they said from the beginning, which is they do not list securities on the Coinbase exchange. Those are not securities.
Yeah. Just to give everybody a rundown on how fast this has come to a head with this particular case. This is the chart of dates. June 6th, lawsuit comes in. They filed the lawsuit. June 7th, court ordered SEC to provide some clarity. June 29th, we get the court grants SEC requested for extension response. SEC response to Coinbase, and now July 13th, first entry into court. Is that fast? That feels fast.
It's fast, and Coinbase's lawyers get the credit here. What they did is not typical in a case like this. I mean, the playbook says, and I was going to get a little technical, I apologize. The playbook says you file a 12B6 motion to dismiss. And typically, lawyers, we want to take all the time we can to do that. And I believe the deadline was around late August for them to do it. And so they jumped the gun by 40 days. You never see that. And they filed an answer, which you never see in these circumstances. If you're going to try to dismiss the case, you don't have to file an answer at all. You don't have to file an answer until the judge has ruled and denied your motion to dismiss. And in big cases, slow-moving cases in the Southern District of New York, that can be 2 or 3 years before you file an answer. They filed one immediately because they wanted to get in some information in front of the judge in their answer, because on a motion to dismiss, you're restricted to only what is alleged in the complaint. So they filed a different motion called a motion for judgment on the pleadings. It's a little technical, sorry about that, but that's why they filed the answer, because they put in a whole bunch of links to information in the answer, like the Hinman emails, the Satoshi white paper on Bitcoin, the S1 registration statement when Coinbase went public, a whole lot of information that's not in the complaint that they wouldn't have been able to use. So they did this and then sent a letter to the judge saying, we want to file a motion for judgment on the pleadings immediately. This is the fastest I've ever seen that done, and I've been doing this for 35 years. So well done by them, and it's working so far. This is on a fast schedule.
Yeah, very cool. All right, so this is a bigger impact question to you about how a spot ETF could be impacted by this. This was a headline. SEC chair casts doubt on Coinbase's role in a Bitcoin spot ETF approval process. So some people look at this, hey, if you're partnering up like BlackRock and many others as Coinbase is your custody company, this may impede your progress as a potential Bitcoin ETF. With what we've seen happen today, along within the markets, what happens now in that particular scenario? Does this play out in a positive sense for Coinbase in terms of how this might play out?
Well, for the ETF applicants, you would think this is highly beneficial. But remember, it's the SEC who's going to make the decision on whether these ETFs are approved, and they're smarting from a loss in court that does have significant ramifications for their case against Coinbase. So remember, it's very easy to imagine a disapproval of the ETF applications on the grounds that your custodian is an illegal, unregistered securities exchange. I could very easily see that used as a reason to deny the applications. But now, when the case looks like it's going to go against them and they're not going to be found to be an unregistered securities exchange, then that argument goes out the window. But let's not forget, ultimately the SEC decides, and you know, they don't have a great sense of humor about losing in court. It's true. All they say about how often they win, you know, it's a very, very high percentage. And so this is embarrassing, the situation they find themselves in now.
They've lost against some high profile cases before. Cuban, you know, kind of outmatched them. There's been a handful of others that have been able to go head to head with them. And it looks like now Coinbase is trying to take that mantle from Ripple and say, hey, we think we can beat them as well. I was looking at this article right here, Coinbase citing a Supreme Court ruling on student loan decision, which just happened. And I know you have a big article on this coming out. First, tell us about what this means to the case and what is your strategy or theory around this?
Well, this relates to the major questions doctrine. Student loan case, the Secretary of Education determined that $500 billion in student loans would be forgiven. And the Supreme Court said, not so fast. Only Congress can do that. Mm-hmm. And interestingly, in that decision by Justice Roberts, he cites Nancy Pelosi, who said in a press conference, people are saying that the president can forgive student loan. This is not true. He can delay payments. He might be able to change the terms, but forgiveness of student loans can only be done by Congress. And Justice Roberts of the conservative majority on the Supreme Court said, Nancy Pelosi is absolutely right. It is only Congress that has the right to make a decision of this magnitude, you know, $500 billion in loan forgiveness cannot be done by a political appointee in the executive branch. That's the major questions doctrine. And there's a good argument that the same concept will apply to what the SEC is attempting to do in grabbing regulatory authority over the entire crypto landscape, both the assets and the trading venues, when Congress is in the middle of proposing laws and debating them about how this will happen. And one of the most prominent laws says that the authority over exchanges will go over to the CFTC, not the SEC. Right. So the point of this line of cases is it's for Congress to decide, not for political appointees of the executive branch. I think it's a very powerful argument. And I do believe that if it has to go all the way to the Supreme Court, that the exchanges are very likely to prevail on that argument. Interesting.
So for many of you, if you're not have been following this for quite some time, simply put, this would put Gensler in a no decision process. He is essentially a political appointee, can't make those kinds of rules and decisions. And now we've got this kind of piling in on within them. Sure, there are securities violations that have occurred with what Ripple has done. But the real question, which I think for the most market, is the rest of the crypto market, which is what has been held back here for the last 6 months due to a lot of what's been happening with the SEC. I mean, you're talking about hundreds of millions, if not billions of dollars have been lost now to American investors because of what's happening in Europe, what's happening in Hong Kong. And we have been kind of, you know, almost demonized in the market of not being able to participate because of all the activities. What kind of impact will the SEC get from Congress? I mean, we saw the FTC kind of got slapped on the hand because of their involvement in the Microsoft case with Activision in terms of the acquisition. Is the SEC going to be kind of in that same boat? Where is this? We're going to have that coming up soon. What are your thoughts?
Well, my thought is, unfortunately, I'm not sure we're going to get legislation actually passed. So we're going to be in this gray area, you know, where there are bills in Congress saying explicitly the SEC has no authority over crypto exchanges Meanwhile, the SEC is suing crypto exchanges saying you failed to register here.
Yep.
You know, and so I don't think this is going to be resolved quickly, unfortunately, unless something very dramatic changes. And like I said, it was kind of interesting that you didn't see the Lummis Gillibrand legislation denounced by the typical anti-crypto forces right away. So maybe there's some room here. I think, you know, you hear that there's some common ground on stable coins, for instance, and maybe this is a situation where if you start to find common ground on something, that it adds some momentum, because that bill is really, really focused on consumer protection. That's what it's all about. And you know, Elizabeth Warren is in favor of consumer protection. That bill gives authority to the CFPB in some respects with respect to the relationship between crypto exchanges and their customers, and what the agreements look like, and things of that nature. So, you know, maybe they were trying to put out some things that she would like, and Sherrod Brown as well.
All right, so I've got a clip here from that and that topic. Listen into this clip right here.
Following the FTX collapse, the new bill adds more language in consumer protection and includes feedback from the SEC. Senator, to crypto fans, that's like, well, it's letters, but it's kind of a dirty word. You getting anywhere at all? BlackRock, Fidelity, who else? Charles Schwab. I mean, these are brand name companies. Why is Congress, they're so behind on what the private sector is trying to do right now? Let's go. Can he point the finger at Congress, or is he part of the problem that's preventing Congress from doing anything?
Well, for a while, he was concerned about some of the definitions that we used in the bill, but we have adopted some of the SEC's recommendations, so it's more clear about what is a security, what is a commodity, about how to deal with ancillary assets, those that don't fit neatly within one of those categories. So we create an authority within the bill that includes people both at the CFTC and the SEC, as well as other agencies that can help sort this out.
All right, so, I mean, they seem to be still very confident about this. There are, you know, we've talked to insiders in DC that they think this one might not necessarily get the legs under it, but now with what's happening just in this short period of time, things could change quickly. I want to jump back to the Coinbase case, mainly because what you're referencing is that most likely the real rulings are going to come from court cases rather than legislation. Before we see that, then legislation will be able to fall back to rule of law and precedents coming into this. In looking at the judges, I just want to make sure we've got the right judges on this case. Is it Catherine Failla? She's one of the judges on it. Is that correct?
She's got the Coinbase case. That's right.
Yeah.
And she's in the Southern District of New York, so she's been around for a while. She knows Judge Torres very well.
All right. So you've got what I would say is someone that's knowledgeable around this. Then you've got Jennifer Reardon also listed on this one. Is she also involved?
Let's see. I think she may have been the one who was replaced at the beginning. Let me see here.
And the reason I bring this up is because if you think about it, Judge Torres has become almost a household name in the crypto community because of her activity and her awareness of what's been happening. And it appears that our judges actually seem to understand what's happening right now from both sides, which is what obviously a judge needs to be able to see through the crap and understand what's law and what's not law. So I think these are good things. Would you say, based on these judges on the Coinbase case, is this a positive draw from the litter when it comes to getting a judge on a case?
Yes. She's been around quite a while, and she's highly respected, as is Judge Torres. And so I get this question a lot. I mean, would judges in the same court come out differently on a legal issue, on kind of an identical legal issue.
Right.
It's
right.
happened. It's rare. There are certain judges on the Southern District that do it a little bit more than others. But I would think that she's going to look long and hard at Judge Torres's ruling and see where Judge Torres ruled that even sales by Ripple on an exchange are not securities transactions. So surely somebody who has nothing at all to do with Ripple, you or me, Paul, trading on a, we're not going to sell a token and then give the money to the promoter or the underlying, project. We're going to keep the money, and so it just seems quite remote to me that that judge would rule that those are securities transactions on the secondary market at Coinbase.
Yeah, for sure. I want to play one more clip here, James. Listen into this one right here. Let's go to this.
Everyone's catching up to XRP holders now. We've been starting and fighting from January 1st of 2021, arguing that secondary market sales are in jeopardy here. Crazy in the SEC's response. I guess not crazy, but they cite the library decision. And they cite the library decision saying that the judge, Barbadaro, did not distinguish in his opinion between direct sales and secondary market sales. And what are we waiting for right now? We're waiting for the judge and library to write that second opinion in order as it relates to the penalties phase. And that's when Naomi Brockwell, who deserves a lot of credit, allowed me on her behalf to go into court and argue to the judge, listen, at least clarify, please, judge, clarify that your order does not implicate secondary market sales. And the judge promised to do that. Now, we haven't seen it in writing, but I point that out to you because a lot of people were saying, why are you going there? It's the penalty phase. The summary judgment was already decided. And remember, I said every single court battle matters.
Yeah. So, I mean, the point he's making is it's probably going to be a lot easier for that judge now to write that opinion in the sense of secondary market sales, which is huge.
Yeah, well, unfortunately, the judge did not do that. The judge very recently, maybe this week, said this question of secondary sales was not litigated by the parties in front of me, so I'm not going to decide it. So that's not irrational for a judge to say that. But I have to say, John Deaton has been really a heroic figure in all of this crypto litigation to, carry the flag for this simple proposition that trades on the secondary market in these tokens are not sales of unregistered securities. And it's a really, really big deal because if they are trades of unregistered securities, Paul, that's a crime. It's a felony under federal law to knowingly sell unregistered securities. So what he is doing in all of these cases, and in Ripple in particular, bringing a class of XRP holders saying, Judge, we do not agree with what the SEC is doing here. The SEC does not speak for us. The SEC is not carrying forward its mission to protect us. It's doing quite the opposite. It's harming us. All we want to do is have the freedom to trade these tokens on the secondary market because they are not securities. So what he's done is very important. I think he was a factor unquestionably in how that Torres decision came out. And so, the whole crypto community owes him a debt of gratitude, in my view.
All right, another breaking item here, James. I want to get your opinion on this. This is a statement from the SEC just made on its first statement after this summary judgment. And if you look at, let's go right to it. We're pleased that the court has found XRP tokens have been offered and sold by Ripple as investment contracts in certain circumstances in violation. So you're right. They took a very sliver of the situation and made it a win. The court acknowledges before the SEC that the Howey test governs securities analysis of crypto securities or cryptocurrencies rejected by Ripple's fabrication test as to what constitutes an investment contract, instead emphasizing that Howey and subsequent lawsuits have ruled that various tangible and intangible assets can be the subject of an investment contract. The court also rejected Ripple's fair notice argument, stating the Howey test is clear and the non-disclosure claim is not a defense for violating securities law. We will continue to review the decision. All right, so there it is. That's the SEC's statement after this. I mean, they obviously took the high ground here. You know, hey, we got our butt handed to us, but here's the good part.
Right.
Does this change anything?
No. You know, the interesting part is the very end there, where they said they're going to consider their options here. So they didn't declare, hey, we're going to appeal, or we look forward to trying the case, you know,
right,
against Garlinghouse and Larson. But, you know, I'm a big believer in markets and the signal that we receive from markets. And the market is blaring a very clear signal on XRP in the secondary market. I don't own any XRP, as well as Coinbase. You know, this threat of this SEC suit has been a significant overhang on Coinbase, and it's certainly not over. This one decision is not a checkmate move by any stretch of the imagination, but it is clearly helpful to Coinbase's cause, and that's the market verdict, and I think they have it right.
Yeah, XRP currently up about 80% here on the day. Obviously, we're looking at the 1 month there. I'll go to the daily just to show you how crazy this wick is for many of you watching this. And, you know, this is kind of a pent-up demand that has been sitting in the market for quite some time. A lot of people anticipated these kind of things out there. I feel like, and we did a video earlier that broke down short-term, mid-term, and long-term effects on the overall markets and a lot of things. So check out that video. Make sure also and smash the like button, because it does help, you know, this video hit the algorithm and other people start to learn about what's going on in these markets, to your point, James, for sure. All right, next up, we've got a couple of big potential regulatory positions in this. You've got the Coinbase case right now. If you're looking at kind of the landscape in general as a litigator and you're watching everything that's happening, where do you think the next fireworks are going to occur?
Well, you know, that's a great question. I did an update on Twitter on about 13 cases, and there's a lot that could break at any time. You know, there's a case that people don't talk that much about out in federal court in San Diego, where a lawyer has asked the federal judge to declare that Ethereum is not a security. And the defendant in that case is the SEC. And the SEC has moved to dismiss the case on the grounds that the claim is not ripe because they have not yet decided whether Ethereum is a security. You know, after, I don't know, 8 years or so of it being out there, which is, you know, humorous and really disappointing, because it's hard for the chairman to maintain the position that it is clear as a bell what tokens are unregistered securities, but it's taken 8 years and still they haven't made up their mind, notwithstanding Hinman, of whether Ethereum is or isn't a security. It's, you know, that's why he refused to answer Congressman McHenry's repeated question in Congress. So that's one. You know, Bittrex is a little bit ahead. They've already filed their motion to dismiss, so that's in the briefing process. The decision in the Grayscale Bitcoin Trust appeal in the DC circuit could come down in the next month.
Interesting.
Now, I've been asked 1,000 times, over the last year, when will the Ripple decision be handed down? And I was wrong. I thought it would have been handed down, months ago. So these things are a little bit hard to predict. But I think that there's going to be a lot of action between now and the end of this year for sure.
Yep. Yeah. And from a legal side of things, I think now, obviously the Ripple, I think, was, the Super Bowl of what's happening from a litigation standpoint. It starts to give a lot of fuel to the fire in all of these other particular cases, which could start to create those domino effects, much like the Coinbase case that you've broken down. If you guys are not following James on Twitter, you should. It's MetaLawMan right there. He does a fantastic job. This is where I met him. I met him on Twitter. And it just shows you, I think there is this whole subculture on Twitter that is crypto friendly, and also everybody's, sure, there's the Moon Boys and there's a lot of, toxicity over there. But there's also a lot of people like James that share their opinions, highly educated, very well versed in these markets. So make sure and follow him. We only trust guys like him when we get into things like this. So do that. All right, we're going to get to a poll. And then we got a few questions here for you, James. Let's go over to the poll real quick. Take a look. Will the SEC yield its war on crypto after this devastating Ripple loss? So I think everybody's kind of on your point, is that this might make them fight a little harder in the sense of saying, hey, okay, we took a little bit of a bloody nose, but we're going to prove we're right, kind of thing. So
yeah, that's what you would think. But, this can get worse for them.
Yes.
This is how they're thinking about it. If they appeal to the Second Circuit and the Second Circuit Court of Appeals affirms the decision in Ripple, that is binding precedent in the Coinbase case, which is also in the Southern District of New York. Southern District of New York must follow decisions of the Second Circuit. So they are now, I can tell you, considering, are we likely to win? What is the downside if this decision is affirmed? How does this impact our portfolio of cases across the country where we're suing people? Because it could get worse. Right now, it's one decision of one federal judge. Having a Second Circuit Court of Appeals decision is a big problem for them if Judge Torres were to be affirmed.
All right. So is this on Coinbase assets? Is that what it looks like we've got another breaking item. Coinbase will re-enable trading for XRP on the XRP network. Do not send this asset over other networks, so your funds may be lost. So they're giving some guidance here. And this appears to be real. So, wow, man, this is happening so fast right now, James. Let me kind of zoom in on that. So for the audience that may not be able to get that, that's coming from Coinbase Assets right there today. So interesting stuff on and I look at this, James, you've been following this space for some time. Obviously you've kind of hyper focused in on what's happening within Web3 and kind of this evolution of where the metaverse might be going, all those kind of things around crypto and blockchain that's changing. When you look at this day, and what happened with Ripple today, I mean, how big is this? Is this Super Bowl event big? Is it bigger than the last bull run, verification of that crypto was here to stay? Is it as big as the FTX debacle? Where would you place it in the chart?
From a legal standpoint, it's big. Now, for it to be considered on par or bigger than Howey, it would have to go to the Supreme Court. Because then that precedent governs all circuits, and that's game, set, match for all federal judges.
Game over.
But, it could get there. This is big. I think it's big for financial freedom as a concept. I totally understand people who don't want to be involved in investing in crypto. Makes perfect sense. Highly risky, volatile, dangerous. But preventing everyone else from doing it seems a little bit un-American to me. You know, and I think also people involved in the crypto industry, there are a lot of legitimate people. They're the ones who want the fraud out of the system. It is the people who are investing their own money in crypto who want the fraud out of crypto, more so than Elizabeth Warren, who has no intention of ever having risk exposure to crypto. It is the people who live it and are building in it and invest in it who want the fraud out. And we want a regulatory regime that is strict, that has audits, that has proof of reserves, that has customer protections, that has segregated accounts, and enforced. If you don't do what you're supposed to do, you get in a lot of trouble. This is why these crypto companies, exchanges, and ancillary companies stampede to the European Union when the MiCA statute is passed, or when something is passed in Singapore, UK, whatever. They stampede there. It completely and totally refutes Gensler's argument that what the crypto industry really wants is to be in non-compliance, that they like being in the non-compliance state. Well, the facts are the exact opposite and you've got to wake up to the facts. We want a good regulatory regime with a competent regulator, and we want the fraud out. And this regulation by enforcement is the exact wrong way to go.
Nice tone right there at the end, James, because it's my exact sentiment. And you're right, you know, the facts are the facts, and we are seeing this massive run toward other jurisdictions. Hong Kong, of course, we did some huge videos on that last week. What's happened with MiCA. We'll see more movement, I think, on the global markets. This will be more of a long-term effect of what will be happening on crypto. Lots of questions. We're going to try to we'll be doing a lot of live streams probably tomorrow. We'll be breaking down a lot of stuff. So, James, thank you so much for stopping in today. We really appreciate it.
Absolutely, Paul. It's always great to be with you. And this was a big day. And I really enjoyed the conversation.
Yeah, absolutely. Okay, thanks. Let's get into it. For those of you who are maybe over on the podcast right now and you missed this live stream and the big news of today, the way you catch up on all this good stuff is jump over here to the YouTube channel, hit that little bell, hit the like button, and subscribe to the channel. It's going to give you notifications when we do these live streams. I would think we might have been one of the first ones out there to break this. At least I know for our audience, it was a big deal. And it's a great place to also meet the rest of the PBN family. You can catch us over on the chats, but you can also get into the Diamond Circle. It's another great place to get additional content, more deep dives, our research, our background that we do on constant research, hundreds of hours per week that are dove into this. If you guys are not following me out there on Twitter, it's very simple, @Paul Barron. We'll catch you next time right here on TechPath.